present. And so welcome everybody, and thank you to Sasha Paul for in advance for this presentation. So Sasha Paul is going to be talking about topics relating to legal ethics and professional responsibility, specifically dealing with remote practice, which is something that in some ways everyone in Nunavut does to some extent. Even if you're physically in Iqaluit, you are very often dealing remotely with people in other communities. So without further ado, I don't know if you're ready.
I'm ready.
All right. So I will hand it over to you with gratitude for your time.
Oh, thank you so much. I see a number of people online. I'm hoping I'm able to get your questions or comments via chat, or if you're able to speak up, I think it would be good. Because I think my hope, selfishly, is to learn also from you good folk about the things that work in your practice remotely and things that have worked for me and haven't worked for me as I've done remote practice. So I want to begin by, again, centering where we are today. What we are talking about is remote practice 101. It's meant to be basic. And I say I've been giving this a lot of thought on the various airplane rides I've taken to come to Iqaluit, which is good to reflect upon what you're doing and what you do better. I think it probably is important to begin by outlining briefly the nature of my legal practice and how it shapes how I practice remotely. And that's really to illustrate how similar or different I might be to your individual practices. So, first off, even though I'm in Iqaluit right now, I'm based out of Manitoba. And for ease of reference, I tell people that I practice in Winnipeg when that's not strictly true. I actually practice on a reserve just on the outskirts of Winnipeg. And I also practice at a relatively, or at least for Manitoba, a large law firm. It's about 100 lawyers. But my office on the reserve is just me. Like, my practice is almost like a little satellite. It's just me in my office on the reserve. I almost practice out of a dorm because I don't have good furnishings. Clients don't come to see me. It is really, really simple. If you come to my office, you'll see my computer and you'll see an old elliptical trainer that I haven't used in a million years that serves as you would expect, a coat rack. I, over the last 5 years in particular, have really depended upon phone calls, Teams calls, etc., because I practice essentially alone. The lawyers at my firm who I work with, I rarely see them anymore in person, even though they're only a 20 to 30-minute drive away from me. What I think is fortunate, however, for me at least, is that because I practice at a big firm, I have an IT department behind me that can straighten things out for me when things inevitably go sideways on an information basis. I'm not that good with with technology, and so I am very grateful for the fact that I have people at the firm who can help me when things start to be a bit odd in that regard. So in that way, I think I'm very fortunate. So again, I'm practicing by myself in the context of a larger firm, but where it also becomes even more, I guess, remote is I'm called in far too many jurisdictions. Like, I'm called in Nunavut, Northwest Territories, Yukon, Saskatchewan, and Manitoba. So what that means practically for me, and I'm assuming for you, is that in many instances, my clients are images on a screen. They are someone who I FaceTime maybe once or twice. In many respects, yeah, Jessica, do you have a comment? No? Okay. What I'm getting to is that my clients aren't with me physically, and it's a treat to see my actual clients in physical form, but it's a very expensive luxury for me, and I'm sure for you, because the cost to bridge the distance between me and my client can sometimes be very great. Like again, just the cost to get to Iqaluit is quite expensive. If I'm flying to remote communities in northwestern Ontario or in northern Manitoba, those flights are very, very expensive, as you will know in this jurisdiction. My practice is a civil litigation practice, and I think that's important for today's discussion. I'll touch upon some of the remoteness and dealing with money in the context of client ID and client verification rules. But I'm not a solicitor that deals with money in trust for the purchases of corporate businesses or for real estate transactions. I have a relatively simple litigation practice. In many respects, my practice touches upon Aboriginal law a lot. So I represent individual Aboriginal people or First Nations on matters. And sometimes those nations and those people are quite remote from where I'm at in Winnipeg. I will say my simple practice, and when it comes to money, I think makes it a bit easier for me when I'm dealing with sort of client identification and verification rules, because again, I am not handling a lot of trust money that triggers client ID or verification aspects. For me, at least, the financial aspect of my remote practice is really getting legal bills paid or getting retainers, and on occasion dealing with settlement funds. I wanted to start with that sort of background to show how I'm situated in the legal market so that you can compare yourself to your experience. And hopefully there'll be some things that are transferable and some things that might be importantly different that we can talk about. What I want to talk about today is dealing with remote practice chronologically. I want to start from that first call or email we get from a client, going through the rules of client identification and client verification, retainer letters, comments about confidentiality, comments about ensuring clients are understanding the legal advice that you're giving them, and to talk briefly about remote affidavits and remote evidence, generally speaking. So that's by way of introduction. I want to begin with the cold call and sort of the initial client discussions. I think it is almost inevitable now. Remote practice isn't all that unique anymore. It's something that I think every lawyer does, regardless if you're in downtown Toronto or in Iqaluit or on the outskirts of Winnipeg. For me, at least, on client intake, most of my clients will reach me, or I should rephrase that, most of my potential clients will reach me via email. And it is becoming increasingly rare for me to get phone calls, actually people calling to talk to me to see if they want to retain me. That I think is important for me. I want to wrestle that initial email intake, if there's something I think I can help with, into a phone call quickly as possible. And there's any number of reasons for that. I want the client to show initiative, or potential client to show initiative, to come and phone me and talk to me so I can understand what they really need. My experience is that the emails I get from potential clients can either be very, very skeletal, like it doesn't tell you that much, or it could be a long treatise that's really hard to understand what's going on. And so trying to develop that initial rapport on a phone call becomes really, really important. And I'm not expecting this is groundbreaking, but I find, at least in my practice, that there is an increasing reliance on emails and texts, almost to the exclusion of phone calls and video conferences. And I think it's important from the outset that when you're getting engaged by a potential client, is to try and do as much as possible that verbal connection, whether it be on a phone or whether it be on video conference, just to underscore the fact that you're there for them and for their legal needs. The other reason, and again, this is basic stuff, that I want that phone call is, as you know, ethically, we as lawyers don't have the right to terminate our clients at will. Our clients can terminate us at will. That's their right under the code of conduct. But we can only withdraw for cause. And so your only real time to assess, is this a client I want to represent? And is this a case I want to represent? Is at client intake. And so for me, it becomes very valuable to have that discussion with people to see if it's going to work. And sometimes it does, sometimes it doesn't. And I don't want to overstate this. Like, this isn't an instance where I'm looking to be the best friend of my client. Like, that's not part of the professional relationship. But I do need to have some rapport with a potential client so that they have confidence in the advice that I give them. Because very early on in the relationship that I have with clients, I have to tell them over the phone that one of the things that I do is I do my best to give them honest and frank advice. And I make it really clear from the outset, sometimes you're going to hear advice from me that you're not going to like. You're going to wish that the law was something different. And I want to be able to deliver that hard news outside of an email or in conjunction with an email, so the client has a better chance to understand it, process it, ask questions, and reflect upon it. But again, what I'm coming to on the initial file intake is making sure as quickly as possible you get yourself to a phone call with your potential client to start getting more and more information about how they interact, if this is a case you can take, and the rapport that you're trying to develop. Of course, on that client intake call, you're doing the basic conflict checks. You know, who are you and who are you fighting against, or who's on the other side? Well, we don't need to go through the magic of conflicts. You know the basics of conflicts. Again, on that initial call, when I'm trying to get some sense as to what this issue is, I also ask how they heard of me. I know it's a bit silly, but for me at least, I'm a private practitioner. Like, I depend upon clients retaining me and paying me to provide legal services. It is good for me to know, not as a matter of legal ethics, but as a matter of marketing and paying my mortgage, how a given person has come to my door. I mentioned from the beginning that I do a lot of work sort of in Aboriginal law fields. One of the odd things personally for me has been, I wrote articles about First Nation election disputes 15 years ago that remain on my website. And to this day, I still get calls on it, and I still get files on articles that I wrote so long ago. I'm actually quite surprised as to how a 2-page article on First Nation election disputes gets me files almost every year. Again, I'm not actively doing that. But again, in a virtual world, in a remote world, I just commend you to try and find out how people are coming to your doors. The other thing I want to do on the client intake call, which again is like a 5 to 10, 20-minute call, is I want to make sure that the client knows my hourly rate and the retainer fee that I want. And everyone has their own language as to how they speak about this with a potential client. And again, I come at this from civil litigation. I try and say to my client on the phone call, say my hourly rate is whatever it is, you'll set it. And to say I need a retainer of this amount. And you'll get a sense as to what retainer you think is necessary. But I'm really, really clear on the phone call to the client. This retainer is just something that puts gas in the car. It is not the full cost of the legal service. Because that's always a concern that I have when I'm on the phone with someone who could be in Shamattawa in northern Manitoba, that they understand what the cost of legal services is, and that it can be quite expensive, and that the retainer that in some instances can be very difficult to scrounge up is just the beginning of the legal fees and not the end of it. I commend this to you because for those of you in private practice, your time is valuable. Your time is something that allows you to pay your rent, to feed your family, and clients should know from the outset what the cost is, so that you know that when you do this legal service, they're going to be in a position to pay. I I'll paper it up later in emails, etc., if necessary. But I really do want to have that conversation there and then, because it allows the client to say, I can't do it, I don't have that money, or I'll get back to you, which is fine. I sometimes clients never get back to me. One of the ways that I end this type of initial sort of call with a client is to say, you know what, reflect upon my hourly rate. And if you don't hear from me again, or if I, sorry, more properly, if I don't hear from you, Mr. and Ms. Client, again, that's fine. You haven't retained me. I'm not your lawyer. You have the decision to hire me or not. And if I never hear back from you again, that's okay. That is a line or a variation of a line I give all the time when I talk to people for the first time on the call. And strategically, I do it because I never want someone who I can't see, who's on another end of a phone call, to hang up the phone thinking that Sasha Paul is their lawyer when I'm not. Like, I want to make sure I express that to them so that they don't think I'm taking care of their legal interests in a way that somehow a limitation period comes up and now people are looking at me for solicitor's negligence. If you're really, really meticulous, I'm not always like this. You can send an email to that effect, but I'm relatively diligent in those initial calls, doing a memo to file, articulating the nature of the issue and how the ball was in the client's court. And again, I do this because I can't really see them. And I want them to know we don't have a legal relationship just yet. When I do, so again, that's the initial type of intake call, getting the basics of who they are, allow me to run a conflicts check, tell them a little bit about the retainer, and then if the ball continues to roll, I'll do a conflicts check, and then I will get to sort of the nitty gritty. If it looks like the client wants to actually go forward, this is when we move from sort of the client intake stuff into client identification and verification rules, which I'm sure everyone knows, but it's always good to go over because the ID and verification rules can play in unique ways when you're practicing remotely in a way that you must be cautious for. So and if we step back, every law society in Canada has its own rules on requiring us as lawyers to identify and verify clients when we retain them. And that, again, conceptually is meant to deal with concerns over, oh, hi, Jessica. I give you a wave so you know that I saw you. Sorry. The purpose of the verification and identification rules is to prevent the scourge of money laundering. And one thing that I'll do, and hopefully I can find a way to put this in the chat or at least commend you to Google it, is because I was the president of the Manitoba Law Society a couple of years back, I will indicate to you that the Law Society of Manitoba has a number of references for anti-money laundering. If you Google that, there'll be checklists and sample agreements as to how you work through verification. I can try and find a way to send that to you during this or after this presentation. But again, when you look at the rules of the Law Society of Nunavut, in particular, section 80.2, you will see the requirements on us to do identification or verification. And so when it comes to this, after it looks like the client is going to retain me for the price that I've indicated to them, and I'm going to begin by telling you my practice and how it's not strictly compliant. I know it's an odd thing for someone who has been involved in the Law Society this long to say, but I want to tell you what I do and then why it's deficient in some aspects. So under section 80.2 of the rules, we have to identify our clients, and we'll use individuals. I won't get into corporations. What I like to do with a client who has just retained me is I like them to send me a photocopy of their driver's license or some other picture ID. And then I do like to have a Zoom call with them where they smile and they hold up their ID and they match. In a pinch, I'll get them to do a video recording of that and send it to me on my phone. I do that because under the rules, we're required to gather information such as your address. I just want to bring it up here so I can put it to you. In 80.2 for, sorry, 80.3, the client's full names, you'll get that from the ID. The home address and home telephone number, it should be on the ID as well. I will say I'm not always the best, and I should be, at ensuring that I'm getting the occupation and the business telephone of a client. I'll do that via email or sometimes during that phone call as well. It's sometimes good to build that rapport with a client as well, to simply ask, what do you do for a living if they are employed. The photo also gives me compliance, in my view, with section 80.3 of the rules, that tells me to record the date upon which I got the information from the client. So I can say on April 10th, I took a photo of so-and-so. That's how I've identified the client. Now, I told you that there was an issue with my general practice. And that issue was this, and we'll get into it in a bit of detail. My process of asking people to show their ID, on Zoom or what have you, will not qualify as verification under the rules. And we'll talk about why. So one of the things that, for me as a lawyer who just litigates, who's not doing a lot of financial transactions, one of the things that I really need to do, and I commend you to do this as well, is to diarize your file on a yearly basis to see, do I need to verify my client? Because as we'll see in a second, verification for clients who are distant from you can take a number of steps and can take time to do so. Perhaps there are happy instances where you say to your client, if you ever come to Winnipeg or wherever you happen to practice, come see me. That can be your opportunity to verify them in person, but that doesn't always work. Life is too busy for that to work. I just want you to make sure that when you identify a client in compliance with the rule, that you continue to turn your mind on some periodic basis, a year or what have you, say, do I need to verify this particular client? Again, if you're doing a corporate practice, like, verification will become part and parcel, because using your trust account to do purchases and sales of shares or land is the nature of what you're doing, so you need to do it quick. But for me, as a litigator, it only really comes up if a client has given me funds that I then need to hold in my trust account and then send off to another party to effect a settlement. If I feel a settlement is coming on and I feel as though the client is going to be giving me money that I need to hold, that's why I want to make sure I'm looking at the file every year to say, do I need to start the ball in motion for verification? So again, I like doing the Zoom call with my client and getting them to show their ID. Again, to build a rapport, to let them know sort of the seriousness and sometimes the oddness of legal processes, because it is odd for an average person to be smiling at you with an ID. I want them to feel that in the safest possible sense, which is when they're retaining me as their legal counsel or you as their legal counsel. When we go to the issue of client verification, that's where things on a remote basis becomes a bit more difficult. And this is where, again, I commend you to at least the Law Society of Manitoba paperwork. One of the things that you can do for client verification, and again, I will say, I mean, I practice in Winnipeg, but I've represented people, northern Saskatchewan, any northern reach that's very difficult to come and see me in person. It makes verification like really, really hard. Like, it's hard for me to get on a 2-hour plane ride to Pumgassi, Manitoba, to see a client to verify them. Like that cost, as you well know, is cost prohibitive. When you look at the Law Society of Nunavut rules in section 80.6 sub 2, I'm sure you all know it by heart. There is an ability, and it says in 80.6 sub 2, that a member may rely on an agent to obtain the verification information to verify the identity of your given client. Now, this is where, again, the Law Society of Manitoba's material can be very, very helpful. One of the things that you'll note in the rules, and I think it's intentional because it's the rules that the Federation, I believe, the Federation of Law Societies created, is there isn't anything prescribing who that agent should be. There is a comment, at least in the Law Society of Manitoba materials, for lawyers to use their good judgment as to who an agent should be for a given person, and a caution by the Law Society of Manitoba, at least, to be slow to necessarily take an agent suggested by your client. There might be a need to have some level of distance between the agent who verifies your client and the client itself. But the point is, there is no set qualifications or set credentials that are required for someone to act as your agent. The Law Society of Manitoba suggests you can use any number of people: lawyers, notaries, accountants, security dealers, real estate agents, people who are familiar with anti-money laundering, peace officers, and justice of the peace. And I even though I was quite involved with Law Society of Manitoba, I'll poke a little fun at them because in my experience, if I'm representing someone in Shamattawa, Manitoba, that's on the effectively the Hudson's Bay, are very, very close, it's going to be very difficult for me to find a security dealer in Shamattawa. Like that type of infrastructure doesn't exist. Like there aren't accountants. The reason they're coming to me is that there aren't any real other lawyers who practice there. Like the list that the Law Society suggests, Law Society of Manitoba suggests, and again, it's not exhaustive, is a list that in many communities that I've been representing just simply isn't available. And so I also have run into issues, not with verification, but with trying to get affidavits signed, that while there might be a desire to contact the local RCMP office to verify a client, for example, sometimes the clients I'm representing are reluctant to engage the RCMP. Sometimes I've considered using a member of chief and council of a First Nation as someone who can verify an identity of a person. But even there, sometimes the cases that I'm involved in are adverse to a given First Nation. And again, there is a reluctance. Sorry. Are you still there? I had a little pop-up come up. I hope everyone is still there. Anyway, the point I'm making is that sometimes the people that you need to verify your client just may not be as accessible as you like. Sometimes you may need to consider nurses at nursing stations in the community or principals at local schools. The other practical issue that I know that you've come into, can you guys still hear me? I'm getting a pop-up that's coming on a lot. And someone gives me a thumbs up.
Yep, can still hear you, Sasha.
Okay, sorry, if I shut off, I I apologize. Okay, I've also run into issues of, while I might want to, again, engage a principal or a nurse to uh, do client verification, sometimes it's hard to get them to actually pay attention to you. They're busy. They have to run a school. They have to run a nursing station. Doing this type of paperwork, ostensibly for free, although I don't think there's anything inappropriate in paying them for this work, is something that they're not interested in doing because it takes away from their day job. Or, and I've experienced this as well, at least in terms of getting affidavits signed. Sometimes people don't even want to witness an affidavit because they just don't want to get involved. They feel as though even just taking an affidavit, or in our case, verifying a client, will be enough to get them into trouble. I don't know if I have any particular solution to this issue. It just shows how much effort can be taken and needs to be taken to verify people. And again, if you're doing a practice that requires verification on the regular, I'm sure that you found ways to make this work. But for me, as someone who doesn't have to do it that quickly, I don't have to think about it until it's urgent. And by that point, it becomes really, really difficult to get an agent in place. In addition to that, one of the things that at least the Law Study of Manitoba's material is quite good at is giving you a sample agency agreement that you're required under the rules to have. So if I do engage a nurse to verify my client, the text of the agency agreement is found, and the directions to the agent is as clear as possible to tell them what to do. And the agent then signs the document, so you can qualify, or you can say that you've met the obligation to verify through that. So again, I'll try and find a way to give you a copy of that letter to the extent that it's relevant to your practice. So that's my quick little introduction about verification and identification of a client on a remote basis. I'm going to move on now to some comments about the retainer letter, if I can put it that way. But let me pause for a second. Is there any questions thus far or comments that people want to raise? And I should say, I'm happy to be wrong. Like, one of the odd things about these types of CLEs is that people come and they think I'm giving, the word from on high. A lot of what I've learned has been by trial and error, doing my best to comply with the rules, and then running into issues as they arise and thinking, I should have done this, or I'll do this the next time. Is there any questions thus far? Can I move on to the retainer letter comments on remote practice matters? Seeing none, I'll move along. The retainer letter, cynically, in some respects, can be seen as lawyers just papering files, that they know they have to do something, they get a retainer letter out, and no one gives two thoughts to it as a file develops. And I can be as guilty as that as the next lawyer, of having the retainer letter go out and then no further thought is given to it. But I acknowledge that we do these retainer letters for a reason. I think one of the things that I want to improve upon in my own practice is ensuring that clients not just read it, but we talk through it a little so they understand what they're retaining me to do and some of the things that they may have questions over. But in the case of a remote practice, one of the things that's in my retainer letter is a comment to the effect of, we will be communicating with you at this email address. I find that is good to have, so that when people change their email addresses, I try and make it on them as the client to let me know, so that I don't lose contact, and to encourage them to ensure that their contact information remains up to date with me. Is it always the problem until it is a problem? I have also found, at least in my Aboriginal practice and maybe in your practices as well, is that for remote clients or any clients, email is great, but texts on your phone are becoming increasingly more and more common. And there is a certain directness and easiness to texts. I don't think I need to tell you how difficult it is to give any level of legal advice or direction through texts, because I find that text, as you're going through on your thumbs on a phone, probably in between walking from one meeting to another, isn't as thoughtful as you might otherwise like it to be. It's a reality that sometimes you have to do, like that's the nature of the speed of legal practice. But I think it's important when you talk to your client, again, remotely, about communication, is to get them to say, or get them to understand, and for you to set this expectation with your client. There will be times when we need to speak. And sometimes you may want to send me a text, or you may want to send me an email, and that's fine. But there are going to be times at which we need to do this virtually. And I want you to be prepared for that. It might be a bit of a pain for some clients to do that, depending upon the speed of their own lives. But I want to make sure, one, the client is aware of that potential cost coming, that there will be a 0.5 on your account because there's a conference with me on a given legal matter. Because I want them to understand the nature and significance of whatever significant legal decision is arising. I want to set that expectation because I feel as though, as I look back at the various bumps in my practice, people get very text focused, and it starts to diminish the nature of the legal services that you're providing. And your legal services aren't cheap. I mean, you know how much you are billing your clients for them. They should get full value. And sometimes that value needs to be expressed in a much more intimate forum than a simple text. So I do want to try in my retainer letters to indicate that you should be expecting these types of phone calls from time to time. I don't know if this is unique to me, but another thing that I am running into from time to time in the clients that I represent is sometimes I have clients that don't have reliable internet access, that don't have cell phones, that they depend upon somebody else's cell phone or somebody else's phone to get a hold of me. I like it to make it very clear to the client and get their consent in either verbally or in a retainer letter to say, there may be instances in which I need to contact somebody else so that I can get a hold of you. And I like to get that consent from the outset, so there isn't any sort of angst on my part of, am I breaching client confidence in saying to a third party, can you tell me where Joe Blow is, and tell them to call Sasha Paul? Because as mysterious as I may be, I know that people can Google my name. They're going to find out that I'm a lawyer and that my client has engaged me for something. I want to be discreet when I'm not calling a third party saying I've been retained on some slip and fall at the Walmart. I'll be very circumspect. But in the retainer letter, I want to lay the foundation for sometimes I need your consent, and you're giving me this consent in the retainer letter to contact third parties when I need to get a hold of you. I don't know if that's something that comes up every so often, but I find in the communities that I've worked in, access to internet and access to finding me can be really hard, at least in Manitoba. Maybe your internet's better in Nunavut. But I think that's a lesson I'm trying to learn as I go forward. And maybe you've already learned that, so this is old news. So those are some comments about the retainer letter. The other thing I wanted to speak about ever so quickly is confidentiality. It's not something I talk about all the time with my clients. Sometimes there is, however, when I'm approached by clients who come as a group, there's the actual client and they bring along family members or what have you. Fine. I understand that people need supports depending upon the legal services that I'm providing. But I do want to make sure that my clients know my role. And sometimes, at least in the Aboriginal law work I've done, there are some Aboriginal clients who need reminding that I'm their lawyer and I'm in their corner and I'm there to give them advice and to keep their confidences. Like, I'm not someone who is going to take what you tell me, Mr. and Ms. Client, and transmit it to the world. And I think it's important at times to emphasize the confidentiality rights that your client has, because in the informality of an electronic age, I think people have acquiesced to just how open the internet world is. And I really want to emphasize with a client, what we're doing is confidential. We want to make sure we take steps to protect the confidentiality. Sometimes I need to remind my client, like, I'll email them my legal opinion. Sometimes I need to remind them, you're going to lose any confidentiality or privilege over my legal advice to you if you send that email off to the casts of thousands. And again, in an email age, it becomes very, very easy for clients to simply say, oh, look at what my lawyer said. And then suddenly your opinion is outside of the rubric of privilege and confidentiality. You'll decide on a case-by-case basis if that's necessary. But again, underscoring the solemnity of what you're doing and the need for confidentiality, I think sometimes needs to be hit even more on the nose in a remote situation than you would if a client is traveling to your office to come see you in your room where you talk about things one-to-one in a space that is already confidential. Okay. I want to move finally away from confidentiality to remote affidavits and the like. And this is where I'm going to betray my ignorance. Again, while I'm called in any number of jurisdictions in Canada, I'm much more familiar with Manitoba. And one of the things that always keeps me up at night as a lawyer is saying to someone, X doesn't exist. Or again, in Manitoba, there is a specific regulation that deals with how you can take an affidavit remotely. There are a number of steps. We'll talk about it ever so briefly. And this is where I'm going to throw it to the group. I haven't seen that in Nunavut. I haven't seen a regulation or a provision in the Evidence Act or the rules of court that would suggest how I can do a virtual witnessing of an affidavit. And this is where I'm tentatively going to go out on a limb to say, I don't think it exists. But is there anyone here who knows of anything in Nunavut about remote affidavits that I've missed? See nothing. again, perhaps as administrative ease, in addition to the Law Society of Manitoba sort of anti-money laundering stuff, I'll try and send out the link to the remote commissioning regulation that we have in Manitoba. And again, it's for Manitoba lawyers, but it does show just how many steps are required to validly allow me to take an affidavit from you on this medium. Again, I have to establish your identity. I've got to make sure the document that you have is the same document that I have, and then I got to see you execute it virtually, and then I got to wait for the original copy to come by, and then I have a special jurat that I have to swear on that document, which is indicating that so-and-so swore an affidavit by video conference on a certain day when I saw and heard that person swear to affirm it, and that I prove their identity by this means, and on this day I got the original document. Like, it's a much more involved jurat than your standard affidavit type of jurat. And again, I raise it only because I haven't seen that in Nunavut or the Northwest Territories. And if someone is aware of it, I would be most pleased to see it. And I give you Manitoba sort of as how, at least how Manitoba has statutorily considered that. I find the Manitoba approach on witnessing remote affidavits to be very cumbersome, very difficult. And it takes time. Like, I remember, again, having to pick on Shamattawa many years ago, pre-COVID, having to going through the hoops of putting together a very involved affidavit, sending it on the plane up to Shamattawa, making my client find someone who could take the affidavit and then get it on the plane and send it on back. That takes a lot of effort. Doing it remotely takes a lot of effort too. But it is, I guess, the realities of modern remote practice. I'm going to skip over remote witnesses because I see we only have about 8 minutes left. The one thing, I think the last thing I wanted to touch upon, which is tangentially related to remote practice, I think just related to legal practice generally, is to remind you that as you're all members of the Law Society of Nunavut, you are also insured by CLIA, the Canadian Lawyers Insurance Association, and that you have mandatory cyber insurance coverage up to very minor limits. I think it ranges from $100,000 to $250,000. The cyber insurance policy deals with privacy breaches. I'm always concerned that someone is going to break into our computer systems and do something nefarious. I understand that has been a reality from time to time. There is coverage available to you right now for cyber insurance. The only reason I raise it is just to ask you to think about the fact that CLIA actually does provide extension coverage. You can buy more coverage. You can take it up from 100K to 250K up to about $1 million or so, in case that's something of interest to you. Maybe it's because I was an old insurance teacher at the law school in Manitoba that I really value insurance more than others do. But I find that this type of liability insurance, when I don't understand all the intricacies of information technology, I get some solace out of the fact that there is the potential for increased cyber coverage, because a remote practice inevitably is going to involve computers and emails. And you may want to think about the CLIA extended coverage as something of relevance to you. I did a ton of talking. I think we have 5 minutes left. Let me pause here. Are there any sort of questions or comments on my ramblings on remote practice, or things you want to share? Oh, I see a chin. Okay.
Hi, Sasha. It's
Hi.
Nuka here. I'm used to working on Teams. I actually don't know how to raise a hand on Zoom, but I just wanted to say, and perhaps I'll go on camera very briefly. There. I just wanted to say that I appreciate your comment on reluctance on having potential clients or clients approaching RCMP for swearing affidavits. I don't work with individual clients now, but it's something that I had run into previously in my previous work. And it's definitely something that's a live issue here in Nunavut, especially in communities that don't have like regional legal aid clinics or they have few like government offices. And there's definitely a need for updated lists for from our territorial government who provide training to government employees on becoming a commissioner of oaths or a notary public. And I'm attending actually this Access to Justice event later this month, and it's something that I'm going to raise because it relates to everyday like legal, legal services and a barrier here. And just on a personal note, I wanted to say that Ben Ralston was one of my favorite professors in law school. uh, him and Shoshana sent me some of your father's books, which I have
Oh,
proudly
that's
on my
great.
bookshelf here in Cambridge Bay. So I just wanted to share that. And thank you for your presentation today. It's been very helpful.
Oh, that's wonderful. I just saw Ben and Shoshana last week because my poor sister had her wisdom teeth taken out and I had to go take care of her kids for a couple of days as she was recovering so that Ben could work. But it is it's a small world. I appreciate you sharing that with me and with everybody. Does anybody else have any other comments, questions, or concerns? Seeing none, I think we can all mark down our hour for continuing professional development on remote practice. And I thank you for your time. I will do my best to try and send out, maybe I can do that now if I know how to work this computer. The materials I mentioned. Of course, the problem with this computer, oh, there it is.